need an introduction because we are so very privileged and honored to have with us thought leaders who understand the intersection of these two fields of law like none other. I would first like to begin with some housekeeping suggestions. All of the attendees are requested to use the question and answer button at the bottom of your screen to share your questions. Questions will be taken up towards the end of the discussion. During the event, you may see some poll questions popping up on your screen. Must I also point out as a disclaimer that the views shared by the speakers, panelists today may not necessarily reflect the views of any organization, entity, or firm that they may be associated or affiliated with. The views may also only be academic for the purpose of this discussion. Anything discussed here shall not be attributable to the speakers or any related organizations unless the speakers or panelists so desire and indicate. And thank you so much for bearing with the mandatory announcements. Without further ado, let me just briefly introduce. Those who know of international arbitration know already of our speakers. Professor Dr. Patricia Shaughnessy, an international arbitrator, a renowned thought leader, is the founder of the ICAL LLM program at Stockholm University, and she also teaches in other related fields such as comparative law, legal methodology, and other procedural laws. We also have Professor Lucas Mistelis, a noted thought leader and an acknowledged authority in international arbitration. He is also the director of the Kumul Unidro Institute of Transactional Commercial Law. Dr. Vesna Lazic is an associate professor on international commercial arbitration at Utrecht University and a member of the staff at the TMC Asser Institute in The Hague. While we discuss these issues now, it was more than 2 decades ago that Dr. Lazic did a PhD and wrote specifically on these issues. Her thesis became this amazing book, which I would recommend anyone wishing to understand more about this interplay, if you guys can see the book. And last but not the least, we have someone that every law student wanting to venture into international commercial arbitration gets to know of in the early days of their law schools itself. A renowned international arbitrator, academician, and director at the Willem C. Wismuth, Professor Dr. Stefan Kroll. Thank you very much, everyone. Our issue of discussion today is the intersection between arbitration agreements and insolvencies. We're going to carry on this dialogue with regards to various aspects that come in, but today we're only going to focus on arbitration agreements. A lot happens on that front, and a lot goes kaput if the scenario isn't understood properly by the courts or by the arbitrators. A lot has developed in the recent days. We had the judgment of River Rock coming in from the UK High Court and the very recent Petrowest from British Columbia. While we would not straight away get into what the court said, we will briefly lay out the facts before you so as to put things in perspective, which our speakers would then use to expand the dialogue. I first invite my friend and colleague Prakhar to take the lead.
Thank you, Ishan, and it's an absolute pleasure to be sitting here and moderating it. It's very, very difficult. People can't even think of the kind of pressure which we are under. But I welcome all the panelists and esteemed panelists. I would want to begin and set a platform with what Ishan left. That's the Petrowest case, which puts across a very, very unique position with respect to what happens between an arbitration and a receiver or an insolvency administrator. In this case, it was the receiver. So the Petrowest case discusses how the interplay between the arbitration agreement and what happens with the receiver and the powers of the receiver. It essentially emanated out of subcontracts between Petrowest and its affiliates, which had an arbitration agreement. One party said that, yes, we want to go for an arbitration. The other said no. The receiver approached the court, and the matter was taken up by the court. And then when it went in an appeal, we came across very, very interesting findings by the appellate court, which indeed is possibly landmark in its own way. And it boils down to, amongst other things, it boils down to one of the most important aspects of what happens and whether the receiver can be considered as a party to the arbitration, because he's representing a lot of other parties against the debtor. So with this, I would request Professor Patricia Shaughnessy to take the lead and go ahead and delve into the nuances of this intersection and the judgments.
Dr. Shaughnessy, before you begin, Can I also just put in, just bring in the facts of River Rock that might help you better in, just taking us through what happens in insolvencies there. So the River Rock case is basically there's the International Bank of St. Petersburg. It's a major retail bank incorporated in Russia that concluded 9 similar contracts for purchasing securities from River Rock Securities Limited in the form of credit-linked notes. The contracts provided for English law as the governing law of the main contract, and they contained arbitration clauses stating that any dispute under the agreement or in connection with it shall be referred to and finally resolved by arbitration as per the LCIA rules. And the seat was decided to be at London. Now, the Russian authorities, they conducted investigation into the activities of the bank only to find irregularities and certain non-compliances. Subsequently, the bank was declared insolvent and the Russian Deposit Insurance Agency was appointed as the official receiver. So bankruptcy proceedings commenced and the receiver, through the bank, sought that the court invalidates all contracts with River Rock. So then River Rock turned to English courts to seek an interim anti-suit injunction against the proceedings that were being carried out in Russia, arguing that the arbitration clauses in the contract required an LCIA London-seated arbitration. The application was challenged by the bank on many grounds. What happened in the courts is something we'll come back towards the end of this dialogue. But before that, I wish to invite Dr. Shaughnessy to talk about the practical considerations for insolvency administrators for bringing actions to courts, and the considerations why insolvency administrator wants to rely on arbitration or not rely thereon. Dr. Shaughnessy, please.
Thank you very much for the introduction and for the opportunity. As we all know, this is the area of insolvency and arbitration poses a very, very rich arena for a lot of issues that are dealt with in different ways in different jurisdictions. So for all of those of you who've been enjoying the Queen's Gambit, you can imagine cross-border insolvency and arbitration is chess in 3 dimensions or more. So it's very difficult to come up with one answer to any particular question. You may be able to do it in a particular jurisdiction, but it's difficult to do it in a cross-border. And these cases that we're looking at today, and of course, everyone is aware of the Electrum cases, which really started us down this pathway, and we'll be discussing those. You can't discuss this space without getting into those. But some of the moving parts, or the chess pieces, so to speak, is we have a range of different regulatory approaches, so that you have to look at the particular national law that may be applicable. And that may take you, depending upon the issue you're looking at, the choice of law that may be involved in the case. And you're looking at different timing. Now I'm going to focus in the couple of minutes I have on when the claim is arising. The bankruptcy has occurred, and then the question of whether or not the trustee or administrator will bring a claim. But the time at which the claim arises and the timing of the bankruptcy also plays in. And in the situation of the trustee, then you very much have the interests of the bankruptcy, the insolvency proceeding, of the public interest in having the creditors treated in a equal and appropriate way, and there are public interests at stake, versus the very private interests in a traditional commercial dispute that goes to arbitration. And so when you're looking at the claimant being that party which has a duty to ensure the interests of all the creditors, whether or not it should use estate assets to pursue a claim in arbitration, because arbitration, as we know, costs money. And so that can create a real tension. So it's not surprising that a bankruptcy administrator or trustee might want to turn to the local courts where the administration of the bankruptcy is going on to bring any claim. The problem with doing that might be, as we see in the cases that we're discussing, that there is an arbitration clause that would apply to the claim if it were the company, the bankrupt, which was bringing it. And in many jurisdictions, the survival of the obligation to arbitrate will depend to some extent on the choice of law. Now, in the case that we're looking at, the one that you just described, in the English case, the Riversop case, there you had it a little bit simpler in that it was going to be under English law and the seat of arbitration was in London. So that, and we all know from recent cases regarding the law applicable to the arbitration agreement that it would lead us to English law. So we had a collection of English law influence here. So it's that made the analysis perhaps a bit easier than if you would have had a different applicable law applying to the merits of the case and to the arbitration agreement. Now, one can understand that the trustee may not want to finance an arbitration. We'll leave aside the possibility and pick it up later that perhaps a third-party funder might be interested. As one can see from reading the case, there was allegedly about 140 million pounds at stake. So this was a case that maybe might attract funding. But the issue that the court was dealing with is whether or not to issue an anti-suit injunction against the proceedings in St. Petersburg. And the issue then that comes up, which is typical in a bankruptcy, are a number of issues that you'll see, and that is the public-private, and is the dispute, who owns the dispute? Who is the real party in interest in the dispute? Is the dispute actually the insolvent company's dispute, or is it the trustee's dispute belonging to the creditors? And that will come up to the issues about, is this a main action or claim, or is this a secondary or ancillary claim? In the case that we're looking at, we did have a couple of parties appearing that had an interest in the bank, the St. Petersburg Bank, and the English court found that they had only an ancillary issue and that they could be potentially joined to an arbitration, but that's another issue. So one has to look at what is the nature of the claim, and is the claim, the English court looked at the Singapore approach, as one can see in the Larson decision from Singapore, which took a different approach. And so if you look at the priorities that were given to these competing interests, you can see the Singapore court takes a different approach than the court in the English court. The English court went along the line of looking at this, is this an issue of arbitrability or an issue of the scope of the arbitration agreement? And the Singapore court, if we oversimplify, we can say they took this as being more important to view this as a question of whether or not it should be subject to arbitration, whether or not the public interest in the arbitration should occur within the context of arbitration. And we know Singapore is robustly favoring arbitration, but in this case, they found that arbitration did not prevail, whereas in the English court, maybe at first glance surprising, they looked at Fiona Trust and the broad scope of the arbitration agreement that would cover this particular claim, and found that the interest of the bankruptcy could be protected in the arbitration. So I'm just throwing these issues out that we're going to discuss. And I think one of the things that becomes important too is that if the claim had continued in St. Petersburg, one can see that would be a natural place that the trustee would bring it. But do you think that claim would be enforceable against the London-based company in the UK? Could you enforce a decision of the St. Petersburg court? If you bring it to the arbitration, then you would be able to use the New York Convention for enforcement. So it's a bit that the bankruptcy, then there was the proceeding in St. Petersburg, there was the counter move for the anti-suit injunction, and we see where the game will play out. Where does it end? So that was just kind of a broad throwing a lot of different issues at you, but hopefully will help to lead us into a number of discussions here.
Thank you, Dr. Shaughnessy. I would, after this, I would request Dr. Lazic, Professor Mistelis, and Dr. Kroll to share their views on this particular aspect, which Dr. Shaughnessy has put forward. Dr. Lazic?
If
Yes.
I may go first.
Sure, sir.
I think Riverrock is a significant case. And I think Patricia set the very many tenets of the case in so eloquently. I think I wanted to perhaps make 3 points in 2 minutes. The first point is the English became acutely aware of having to distinguish themselves from the Singapore court in Larsen Oil, in the sense of setting a presumption to be followed by future courts. And then in English court, unlike Singapore, there's no presumption that the company's insolvency changed the dynamic of claims to be arbitrated. The second point I want to make is a point of private international law. I think the English wanted to make sure that there is a classification of the actions of the remedies before the English courts. And I think Patricia was very right to say that for them, it was an English law claim, an English law remedy, and is classified as a matter of English law. And as such, the more classical question of whether it is a matter of substance or procedure is not as critical, but perhaps the substance of the claim is English and is also situated in English. And the third point I wanted to make is very similar, but with slightly different wording on the Fiona Trust. The English test is whether the scope of the arbitration agreement is broad enough. If the scope of the arbitration agreement is broad enough, then we have a very specific concept of arbitrability rather than the broader public policy arbitrability. And that sort of the more sort of American almost gateway arbitrability would be sufficient to trigger the protection of the arbitration agreement. And I think that's what the courts wanted to say. And I think they said very, very robustly. And interesting enough is the second case within a year that the English courts have to say something of the same nature.
Yeah, quick question to Lucas. In the court's decision at paragraph 64, they talk about substance over form. Do you think the English court was taking a pragmatic approach?
Absolutely. I think the English judiciary is very acutely aware of what is coming at the aftermath of the pandemic, and which has not yet been felt in a business in the legal sense. And they think that there's a pragmatic approach, and I think there's a genuine, to use the paraphrase, the title of the webinar, there's a dialogue between national courts and arbitration tribunals, and they think that distributes, delegates tasks as best is served in the interest of justice. My 2 minutes are up.
You want me now to address the issue? So thank you very much. I prepared a presentation on the issues that I was supposed that we were going to discuss in the first round, but I will skip those slides. And just a second. Can you see my presentation? Yes. So I will then skip those remarks that I kind of prepared for the technical and practical considerations for the insolvency administrator and concentrate on the case that we have that is presented here. So there may be, I would then continue until the nature of claim. And simply, I would say that I was very much surprised by the decision of the English court, because we have in the comparative law, this is something which is called, which is typically avoidance powers of the trustee. These are the statutory, so-called statutory causes of action. And it would be really, I was very much surprised to find that arbitration clause extend to such types of claims. I just wanted to I'll skip executory contract as well. and come to this. Yes, so these are just a few examples that I prepared to illustrate how in other jurisdictions the question of the avoidance powers of the trustee was treated. So normally it is held, these are statutory causes of action, which are basically given to the trustee. These are not causes of action that belong to the debtor. So in such a cases, that would be very, very exceptional, that they could also extend to arbitration agreements. So we have here some examples from United States, and that is the position which has been constantly held. The same example we have here from the Dutch court, from Germany. The same position was also held in the Singapore court. We have here two cases. There was also Nori case, which was preceded to Riverrock. And this case, I was not so much shocked, because this is also, there may be a question whether we really had to deal with the so-called genuine avoidance actions. Because in that case, there were two sorts of actions of the trustee. Avoidance powers, so allegedly on the basis of the bankruptcy code, but also abuse of rights and conspiracy to defraud, which are basically normal actions on the civil code. So in that case, I would rather see this as a kind of a move of the trustee to call it all avoidance powers, when in fact we were not sure whether they were really avoidance powers of the trustee, because the party was not no longer insolvent at that moment. In the Riverrock, however, the court was very clear. The court stated, we do consider them as an avoidance powers of the trustee, A. B, they are statutory causes of action. C, we also have that in England, in English law. But again, we are still going to hold it as kind of having effect also with respect to arbitration clauses. Something I think which is also maybe important to mention here is all of those cases that are, including the Norrie and Riverstock case, they deal with the cross-border insolvency. And all other examples which we found in the non-binding nature of the trustee, many of them were considered in the national and domestic view. So what we have here is that certainly Riverrock, we should not conclude that English courts would generally hold trustees bound by arbitration agreements, even in a purely domestic case. So that's what I wanted to say for the time being. On other topics, maybe if there will be some time left.
I would like to pick up on that one. I think it was a very important point, as Wesner pointed out, that the courts probably took into account also what would have been the alternative here. And the alternative would have been, we have proceedings in the two cases in Russia with the Russian insolvency administrator bringing actions in Russia against the parties there. And I agree that maybe in a purely English domestic case, they would have decided differently, because I think there are two questions here which somehow are interrelated, but have to be separated clearly, in my view. The first one is the arbitration agreement as such at all binding for the insolvency administrator or the receiver, or however you call him or her. So that is a question which is very often regulated, relates to issues such as objective or subjective arbitrability. And then there's a following question: if it's binding, does it really cover the particular rights? And we have here a situation, and that comes out clearer in the Singaporean case, where you say, okay, we have the original debtor who had certain rights, but the original debtor never had the right to annul the case under insolvency statutory proceedings or provisions. These rights only arose after insolvency had been declared, and only arose for the insolvency administrator. So the question, at least it has been phrased like this in the German courts when they had to deal with the question, was, is the debtor at all able to basically dispose of rights which never existed for the debtor, but only existed for the insolvency administrator? So, and the answer by the German courts was, and I think that's convincing there, it's a clear no, because you cannot basically agree to arbitrate rights of a third person which do not belong to you. And I think that was a little bit, that was clearer framed in the Singaporean and the German provision. I don't know the Dutch case, but this is a separate question from the first question, which is also very controversial. Is the arbitration agreement at all binding for the insolvency administrator? And I think that will be one of the issues we discuss when we look at the cases from the different perspectives then.
In fact,
yeah, sorry.
Am I audible?
Yes, yes.
In fact, I would request Professor Kroll to take up the issue on approaches by courts of the place of insolvency when the opposite side or the other party has invoked the arbitration agreement, and what are the approaches in different laws, because it is now given the points from the panelists, it has now become all the more important to look into those practices and perspectives.
Yeah,
Professor Kroll.
Yeah, thank you very much. So I have now the easiest task, to discuss what the court at the place of insolvency will do. And the courts at the place of insolvency will naturally look into their own insolvency law or their conflict of law provision or whatever, where you find them, but primarily the insolvency law. The only problem here is for these courts, the insolvency law is very often not completely clear in its relationship to arbitration. You have in a number of jurisdictions, you have a clear provision where it says arbitration is possible, arbitration is not possible. But in a lot of jurisdictions, you just have a provision which says this happens to court proceedings, but it doesn't say anything what happens to arbitration proceedings, neither in the insolvency law nor in the arbitration law. And where these specific regulations exist, they often differ considerably. And it's always the same question, which arises in every jurisdiction, whether they have a specific regulation or whether they have no specific regulation. And that's a conflict between the various interests involved. On the one hand, you have the interest described by Patricia at the beginning, the public interest, the interest in treating all creditors equally, interest in increasing the value of the estate, avoiding spending money on litigations, on separate litigations. And that comes out very clearly in the first instance of the Canadian case, where they said we would have several different arbitrations, but here we can deal with everything in a single procedure because you can join everybody. So that is the public interest. On the other hand, you have the interest in the party's agreement to arbitrate, in party autonomy. That just one party became insolvent does not remove the interest for the other party, instead of ending up in the state courts, going to arbitration. And then you have to balance these interests somehow. And as I said, some jurisdictions have tried to do that expressly in their insolvency law or in their arbitration law. Others have tried to do that via case law. And when you look at the jurisdictions, whatever approach they took, there's a whole spectrum of approaches. On the one hand of the spectrum, you have the jurisdictions which say these types of disputes are as such non-arbitrable, either objectively non-arbitrable or where they say the insolvent party loses its capacity or in subjective arbitrability, which means there is no arbitration over these disputes. And one example is the Latvian Arbitration Act, which says in Section 5, number 8, listing the various areas where you have non-arbitrable disputes, they list disputes with insolvent parties. And then you have the famous Vivendi case, which was already mentioned by Patricia, based on the old Polish insolvency law, which has been interpreted by the Swiss courts at least to basically deprive the insolvent party of its subjective arbitrability. In these cases, at least for court at the place of insolvency, there is no conflict with arbitration because arbitration is not possible. So that's the one extreme. And then we have the next one where you say, okay, it's arbitrable, the disputes are arbitrable, but maybe the insolvency administrator is not bound by a pre-existing arbitration agreement. And the difference is the insolvency administrator is not bound, but he or she may enter into a new agreement, which would not be possible if the dispute is not arbitrable as such. And there you have some which would say, like, for example, the Portuguese law, which says the arbitration agreements concluded by the debtor are not binding on the insolvency administrator. And then you have other countries which say maybe they are binding on the insolvency administrator, but the insolvency administrator has the discretion to decide whether he or she wants to be bound by it, or in the interest of managing the estate, increasing the value of the estate, want to basically terminate the agreement. And that's the interesting part in the Canadian case, where they said there may not be a general power to do so, but the arbitration agreement is what we call an executory contract which then can be terminated by the insolvency administrator. And the funny thing was, they said it's only the arbitration clause due to separability which has to be terminated or can be terminated by the insolvency administrator, who in the end can benefit from the rest of the contract, because we have the doctrine of separability. And last but not least, at the other spectrum, we have the jurisdictions such as Germany or others, where in principle the insolvency administrator is bound by the arbitration agreement as far as it reaches. That would be the second question then. And the only thing which is required, that the insolvency, the fact that there's an insolvency, has to be taken into account in the proceedings, which means you have to register the claim with the insolvency administrator. Maybe the claims have to be amended, whatever, but the arbitration agreement as such remains valid and has to be enforced. In the Russian case, they decided under the Russian law, this is not arbitrable, the dispute, and in the St. Petersburg court would have heard the case. As I said, that is the first question. The second question then, if it's binding, is it really covering the particular dispute? And here I see the point the English made, but I humbly disagree with the solution and would favor the solution adopted by the Singaporean case, not to mention the German case. Thanks.
Well, thank you so much, Dr. Kroll. Professor Mistelis, would you like to touch upon the various approaches that the courts might take, if you have something to differ from what Dr. Kroll said, or add to it?
Well, as co-author and friend of Stefan's, is not upon me to disagree with what he says. Perhaps I can supplement that the draft new Greek arbitration law has also adopted a procedure, a provision. It's not yet adopted, but it has a provision that insolvency has no impact on the validity of the arbitration agreement. So they have taken that a very express statement, and it's interesting that it's done by a country like Greece, because, as you know, Greece has suffered severely from the last financial crisis, and it might suffer again. But they felt, some of the drafters of the arbitration law are perhaps closer to civil procedure than they are to arbitration. But they felt that in making justice more efficient, then sort of leaving the arbitration untouched, where a valid arbitration agreement exists with appropriate scope, that's the right thing to do. And in that sense, a sort of Greece perhaps is closer to Germany. I would think that the point that Stefan makes, but perhaps also Patricia and Vesna did, is the English are notorious for being very pragmatic, and also I think the English have taken the view that the justice as administered here is perhaps one of the best places in the world, although one can argue that this is also the case in the United States from what we hear in the last couple of months. But in that sense, and protecting the integrity of proceedings under LCIA rules, I think it was critical. So not much of disagreement, just an addition, effectively.
Thank you. Dr. Lazic, you have a lot of experience in your understanding and practicality with regards to what happens in many European countries. What would you like to add to that?
Thank you so much. I will try. I will again refer to a couple of slides, and I can't possibly address all of those which I prepared, but I will just pick up on a couple of points here. In particular, the idea. Yes, I will just have to go back with the first part. Of course, the first point raised by Stefan is these exceptional approaches. Some countries have really very, I would say, very specific and very strange provisions, express provisions in the law that arbitration clauses are invalidated. One should be also very careful in taking such provisions to be applied extraterritorially. And also, I think arbitrators should not be applying those provisions, because sometimes it is maybe even obvious that those provisions don't even tend to be applied internationally. The reason that I'm picking on that point is you can see on this slide a court decided by the Spanish court. Spain has a very similar provision like Polish in Vivendi case, invalidating arbitration clauses. However, the court decided here within the context of Article 2 of the New York Convention, stating, well, this is basically for domestic cases, and in this case we will stay proceedings and revere the parties to arbitration, ICC arbitration in Paris. Also, I would say that this is very, very difficult to find out what is rationale behind of such provisions. It is really, really doubtful whether they are at all in the interest of the trustee or of the estate, whether they are in the interest of the general body of creditors. In particular, it may be beneficial sometimes for the trustee to arbitrate, and basically these provisions deprive the trustee from arbitrating even the disputes which are already, for example, in advanced stage of arbitration, and they are generally detrimental. They are fortunately just exceptional approaches, and this is also what Stefan suggested is majority approach is, as a matter of principle, the trustee is bound by pre-bankruptcy agreements. However, there may be certain exceptions. Exceptions may be divided in the different methods, I would say. Ones are those which are really originating in the insolvency law. These are the avoidance powers of the trustee and the possibility to repudiate the so-called executory contracts. And there may be also an important part of the discussion is also pending legal suits. And then maybe I know that some definitely arbitration community would not agree in applying those provisions automatically to arbitrations as well. But basically, from the point of view of insolvency law, there is no reason not to, because legal proceedings normally would include arbitration. And later on, we can see also some slides in which it is obvious, for example, that certain provisions like automatic stay are meant to be also applied in arbitration. And the last point on executory contracts, just about the British Columbia case. Again, I would say that it is rather exceptional view, because normally it is somehow taken that if the trustee accepts the executory contract, it is also should accept the arbitration clause contained in such a contract. What is executory contract? The contract which is not fully performed by either party. So that's why there is a possibility for the trustee. However, it is the possibility to repudiate the contract results in the claim for damages. So the other party becomes basically ordinary non-secured bankruptcy creditor. And in such a case, then the question may arise, what will happen if such a claim for damages is then later on contested in verification? So that's something which we may address later on. But we can see here that, for example, under English law, there was express provision, the previous, it's Section 3 under the 1950 Act, which is now basically introduced in insolvency, stating exactly the same for the insolvency of the individual, that the trustee will be bound by the arbitration clause if it accepts the contract. The question is what will happen if and in that sense, the decision of the Canadian court, in my view, is at least the first one which I see, in which the court states that because of due to the separability of arbitration clause, the trustee may accept the main contract, but does not have to accept the arbitration clause. So in that sense, it's a rather exceptional approach. So I will, well, for the time being, I will just stop sharing slides.
Yeah, so the British Columbia Court did exactly what you said should not happen, and then carving out the exception. So yeah, Dr. Shaughnessy, your take on this, please.
Thank you, Vesa. That was a really content-rich presentation that you managed to give us. And one of the points that you made initially and you brought back here, and that was the nature of the claim. If the claim, if it's an avoidance or repudiation, or is it's an unfair transaction recovery, so that it's retroactive. And then we see in the River Rock case, the court talking about who owns this claim, and taking that ownership issue to whether it's a claim that arose out of the bankruptcy law or a claim that arose out of the contract. And the English court goes to that it is a contractual based claim, and that the trustee then is part of the arbitration agreement. And it seems like the way in which that's characterized, which is this the main claim, and how do we characterize it? I think that makes a real crossroads in your analytical pathway. And we see that in the Singapore case, and we see it in the River Rock case, because it's difficult to say when the right to retroactively repudiate or to claw back the transaction arises out of the Bankruptcy Act. And if that act in some countries, as in the River Rock case in Russia, says that this is not arbitrable, and specifically you have some countries like Russia, like Ukraine, where they say the court has exclusive jurisdiction over the rights deriving from this Bankruptcy Act, then it seems to be a bit difficult to clearly put it into a contractual right, which could be subject then to arbitration. So it seems a bit that the policies underlying are to a great extent influencing the harbor into which the court wants to end up in.
And once we reach that stage, of course, these are the various nuances that occur, especially when we start considering how the courts in the jurisdiction of the Insolvency Act, and we've seen different kinds of decisions or different kinds of approaches. But let's say we land up in such a scenario. Dr. Lazic, I invite you to talk about the tactical considerations that creditors should have vis-a-vis the arbitration agreement, especially given the light, what happens in British Columbia, or say, for example, the River Rock case, or Vivendi for that matter.
Thank you so much. I will again go back to the presentation. So let me see. So these are the, well, I was kindly asked to prepare something on the actions of the courts to protect insolvency proceedings from arbitration. And so, and to address the issue of what approaches may be taken by courts in the country where the insolvency proceedings are opened when the party invokes the arbitration agreement. So basically we could see, we know that there are three instances, so to speak, in which the courts in the country of the opening of insolvency proceedings may address the issue of giving the effect to arbitration agreement. So one is obviously within the context of a stay of proceedings and referral the parties to arbitration. So the courts may, in the country where the insolvency is open, simply refuse to refer the parties to arbitration. So here again, trustee is not always even free in making that decision. Sometimes, and very often, there will be needed the court approval of such referral to arbitration. And sometimes the courts simply may not be willing to do so. Here is, for example, one case. The question is, what would be then the consequences of that? Can the courts in that jurisdiction at all control, so to speak, arbitration? Well, only in the if later on would be a possibility of recognizing in the procedure for recognition of such an award. So here is an example of a United States case in which the court refused the parties, so-called, to compel arbitration. Arbitration was in a very, very advanced stage, basically within a month after the denial of the motion to compel, there was an arbitral award which was rendered. And one would expect that violation of such insolvency law principles would result in the refusal of recognition. However, that was not the case here. So very important to mention here was that creditors did file for verification in bankruptcy proceedings. A and B did request for the compel to arbitration. So the second question would be indeed whether such an award would be accepted as a proof of claim in verification proceedings. Obviously, in any limitations that may be in the insolvency law, they may be effective when the arbitration is taking place in the same jurisdiction, because that will be the courts which will also exercise the setting aside proceedings and the annulment proceedings against the arbitral award. So in that sense, such a violation may be sanctioned, so to speak. Possible grounds would be either violation of public policy. In France, we will see some examples, and they are really very, very strict in application. Those rules when the rules of insolvency have been violated, they are considered as part of domestic and international public policy in France. So that will basically inevitably lead into setting aside or refusal of recognition and enforcement. And of course, in the enforcement proceedings, that will be also a possibility to kind of exercise this influence of insolvency that tends to have to arbitration. So, and here you see there are some examples in French law, as I mentioned. Any basically violation of any provision of insolvency law is considered as a part of public policy. And even in some cases, for example, when the creditors would be filing the claim in bankruptcy, and then obtaining the award, I would say a case in which really went too far. It was the case that arbitrators rendered a condemnatory arbitral award. And so it was set aside because, according to the view of the French Supreme Court, arbitrators may not bring about condemnatory judgments, only state the damages, but they may not be of a condemnatory nature. So I would now like just to concentrate on one specific topic here. And this is something that is very, very usual for insolvency proceedings. So these are not provisions that are like ones that Stefan mentioned and we saw in Polish law invalidating arbitration clauses. These provisions are very common. And this is one of the basic principles. Creditors are not entitled to pursue individual actions. They may not satisfy their claims outside of bankruptcy proceedings. And this is a very essence, basically. And also such creditors are the so-called ordinary non-secured bankruptcy creditors, which have to be treated equally, and they are basically the lowest rank of creditors. So what we have here is normally every bankruptcy law, I would say, would contain a provision stating that there must be either an automatic stay or that the trustee may ask for the stay of proceedings. With the purpose that a claim is first filed in the verification proceedings, and only if contested in the verification proceedings, such claims must be resolved either outside of the bankruptcy court or within the bankruptcy court. That depends And that is an example that Patricia mentioned. Some courts may have really vis attractiva concursus, meaning that they would like to attract all types of disputes, including verification disputes. And sometimes this may result in non-arbitrability. What is really clear is that such provisions are clearly intended also to be applied in arbitration. Sometimes it either follows from the parliamentary history of the Act, sometimes from the case law, but it is generally in majority of jurisdictions it is held that they also should apply to arbitration. Here are examples from the English insolvency law, both in corporate winding up as well as in administration. They simply should be applied. So the second issue I was asked to reflect on, what would be tactical considerations of the creditor continuing or initiating arbitral proceedings despite opening of the insolvency proceedings. So there is basically two basic scenarios, is that a creditor would like to have a proof of claim in bankruptcy proceedings. So in that sense, the creditor files for the verification and continues. That is exactly the case which I mentioned from the United States. And that was later on, whether or not it will be admitted to verification, that's questionable. Also, continuation of arbitration without filing the claim. First of all, creditor may be too late to later on to file it in insolvency proceedings. But what I think would be the major intention of such a creditor would be, of course, to attempt enforcement of the arbitral award outside of insolvency. So basically in another jurisdiction. We have also many examples that it did happen, in particular in the cases of cross-border insolvency. So whenever arbitral tribunal, more often when arbitral tribunal had a seat outside of insolvency proceedings, they simply continued. Here are just a few examples of arbitral awards that happens. So then the question is, this approach and automatic stay, how effective will that be outside of the bankruptcy proceedings? So basically, in the absence of the recognition of foreign bankruptcy, they will have basically no effect. That's what we see also here from the French court that I mentioned. On the other hand, here are some examples in which that was clear, that the courts, even in the other jurisdiction outside of the insolvency, did not allow creditor to bypass, so to speak, insolvency proceedings and enforce the award in the third country. This case is a case in which the creditor ignored the bankruptcy proceedings in Sweden and continued arbitration in London and attempted to enforce it in the United States. But the court simply stated that it recognized the effects of the insolvency proceedings and which prevented the enforcement of the award. I would conclude this short presentation here just by stating that it is, I think, in this world in the globalization era, it should be really effect to foreign bankruptcy proceedings should be given. And the second, a very important question would be here to find a way either to unify the conflict of law rules in such a situation, or that the country, when enacting the cross-border acts in the jurisdictions, also provide for a clear conflict of law rules.
Thank you, Dr. Lazic. Thank you so much for that. That was actually a lot. Specifically, your take on the French perspective in Almera films. That's very interesting, and in fact, go a step ahead. What happened in Casa versus Cambior also is a good reflection of how seriously the French take it. And in fact, since we are discussing it in the perspective of the restrictive approach and what we saw in Petrowest, makes it all the more obvious that to what extent can courts go to protect the insolvency proceedings. And in fact, Professor Shaughnessy also in his remarks in the last round talked about who owns the claim, and then things start filtering down. Professor Shaughnessy, would you want to take it up for your comments on Dr. Lassett's approach?
Well, I think I'm going to pass and let Lucas make some comments on that instead, if Lucas is willing to do that.
It's not a matter of willingness, but I think the time is limited, and I think what perhaps I would like to comment on Vesna Lasic's very comprehensive but very short presentation is that we have actually the essence of the dialogue really reflected in the different approaches, and the fact of the matter appears to be that insolvency is always seen from the perspective of a single domestic legal order. Of course, cross-border insolvencies have been on the agenda for nearly 30, 35 years, when we have had some of these very big insolvencies. I mean, perhaps one of the last largest ones was the Parmalat collapse, which had sort of implications in multiple jurisdictions. And there were a lot of English banking insolvencies in the 80s and early 90s, which had, again, multi-jurisdictional impact. Now, but the way insolvency has been regulated has always been from the perspective of a domestic law. Manuel Penades makes the comment very well that there has also been attempts to unify cross-border insolvency by the Ansital model on cross-border insolvency, and is a matter of a bigger debate, not for today, whether this has been a successful attempt to bring about some sort of harmony. But I think perhaps within the EU we have certainly made more progress in that respect, and the polar position, the antithetical position, is the position of the arbitration tribunal, which sits on a quasi international legal order. It's an award that will circulate much quicker than any judgment of any insolvency court, and will be enforced much quicker. So a tribunal looks at sort of domestic limitations to their powers and international aspects of their powers, which are based on an arbitration agreement which is embedded in Article 2 of the New York Convention, and perhaps the local arbitration law as well, and with an award that can circulate very widely. So what tribunals perceive to be the issue is effectively three things. One is the integrity of the arbitration process before this tribunal. They need to ensure that the arbitration doesn't become shambolic, doesn't become chaotic, but it's also meaningful in the sense that the outcome of the arbitration is enforceable. So that's the other sort of the bigger picture of any arbitrator. But in order to get there, they need to do two things, which are both of which are very critical. They need to establish their jurisdiction against public policy limitations that they might exist, against concerns about the validity of the arbitration agreement. And in doing that, as we know only too well from recent case law, we have a number of choice of law issues, with the validity of the arbitration agreement, how we assess it, who are the signatories, who are the real parties, how a receiver becomes a party, and also a lot of different jurisdictions see insolvency administrators or different stages of insolvency administrators in very different ways. I mean, just to pick up an example, the recent Ukrainian law reform, which relies on Austrian law, it has a trustee or receiver in insolvency as the omnipotent sort of administrator of insolvency, but also has a concept of a property administrator who has particular task for the administration of certain assets, which, as per Ukrainian law, doesn't seem, for example, to have the same extent of powers as the broader receiver. So that comes before a tribunal, and they have to see whether the property administrator is the same as the insolvency administrator, and they have the same powers of representation or not. And very often the solution is by almost becoming immune to some sort of demands that come from a domestic system. But in looking at the integrity of the process, the enforceability or the best endeavors to render an enforceable award, and navigating through conflict of laws as it is very on the point here, that we simply we are all over the place internationally as to what are the proper choice of law rules for insolvency and how these are sort of relating to arbitration. So I think what arbitrators want, and to paraphrase a word that has been used very much by the Stockholm Chamber of Commerce, are peace administrators. and in that sense, it's administering peace and administering a process that has been referred to them by party autonomy. They really struggle about being technical or legally correct or being pragmatic, and effectively stretch pragmatism to the word that it does, to the extent that it doesn't conflict with legal repercussions and legal validity of an arbitration. And that's why you would see that a lot of these processes take a bit longer to resolve, or they go very quickly, and they take very much longer if the tribunal wants to be very, very inclusive and make sure that hears every likely party, even if to the extent of rejecting the power of a particular person to represent an insolvent party. So I think that's what I would like to do in the very limited period of time I have, to allow other people to make comments. And I think that some of my colleagues will also have other things to say.
If you would allow me to comment on some of the issues which were just mentioned by Lucas, when he said the arbitrator may have a slightly different perspective than the state court. The state court is in general always bound by its conflict of law rules. Yeah? And if you sit at the place of insolvency, you're probably bound by the insolvency law, because that is mandatory law in most jurisdictions. You cannot do anything. It may be different if you are at the place of arbitration, because you may not be bound by the insolvency law of the other party, but you may have special conflict of law provision which tell you to basically give regard to the arbitration. But the problem for the arbitrator is the arbitrator has no such directly binding conflict of law provision. So he is much, or he or she is much more left with the underlying considerations which also underline the balancing process in the laws. What are we dealing with here? Is on the one hand, we have a justified legitimate interest of a party which agreed to arbitration to basically rely on the arbitration agreement. And some of the insolvency proceedings get the impression that the party was fleeing into insolvency to avoid existing obligations. Yeah? So for example, in the Vivendi case, at the beginning, it wasn't 100% clear whether they were really insolvent or whether it was just a way of getting out of a number of obligations they entered into. And also the Russian case, it's always very difficult to really appreciate, is there someone trying to defraud the bank, or is there someone trying to get basically the ownership of the bank by using the insolvency proceedings whatsoever? That naturally we might influence an arbitrator as well, seeing whether he or she accepts the insolvency restrictions existing or not. And I think also the arbitrator is probably affected by how generally accepted are these restrictions. If you have a very restrictive law which says these disputes are not arbitrable, it's much more difficult for an arbitrator sitting in a different jurisdiction to accept that, because the tendency now seems to be, we acknowledge there is at least some room for arbitration. And Vesna, for example, mentioned that quite interesting Spanish case where you could say, okay, the Spanish have realized that in domestic cases, purely domestic cases, it may make sense to abandon arbitration because it's a domestic case and the benefits of arbitration in domestic cases may be more limited than in international cases. While in international cases, we accept that the arbitration agreement prevails. These are all considerations which you have to take into account as an arbitrator which makes result for the parties fairly unpredictable to some extent, yeah, because it depends a little bit how the arbitrator sees his or her role and what their understanding of the underlying principle is.
Dr. Shaughnessy.
Yes, Dr. Shaughnessy, please.
Thank you. I want to just pick up on something that Stefan said and turn it around a bit. And that is, think about the situation where a creditor or a claim creditor is pushing a potential debtor into a bankruptcy proceeding. And then the debtor says, this is a disputed claim. I don't owe you this. I don't belong in bankruptcy. And we are subject to an arbitration agreement. And that's where this claim should be decided, not here in the court. And indeed, we know in some jurisdictions, no names given, that there have been problems with misuse of bankruptcy proceedings to manipulate and to exploit other parties. And that might explain to some extent sometimes too why that there may be some different approaches and protections. But I think that that's turning your problem around.
Dr. Lazic, please.
Thank you so much. I just want to make a short comment also on everything said, including Luca's comments. First, I would like to mention just what I stated in connection with the clear conflict of law rules in case of insolvency. I really must say that I think here more in the terms for the national courts when they have any functions in arbitration. As regards to arbitrators, I fully agree with Lucas that they should be kind of more pragmatic. And I think that for arbitrators, instead of really getting lost in those conflicts of law rules, we have seen that in Vivendi case, both in Switzerland and in England, it was difficult and they just didn't manage, in particular, the Swiss court. So in that sense, I think that arbitrators simply should follow basic rules and basic principles of arbitration. So first of all, to give the opportunity, equal opportunity of a party to present the case. So that brings in itself that certain direct, immediate application of insolvency law, because that trustee depends on that law to be involved in these proceedings. And secondly, I believe that it is also good for arbitrators to make this balance. To take into consideration not some very strange provisions like invalidating arbitration clauses, but certainly to at least take into consideration some provisions which really protect basic principles of insolvency law. So I think that's pragmatic, and I would say that this is really the most safe way for arbitrators to have an enforceable award.
Yes, Dr. Pro.
Yeah, since Patricia directly suggested that the other problem we haven't touched at all upon, yeah, which is a principle, a pre-arbitration, a pre-insolvency problem. Yeah, you're pushing someone into insolvency, you start an action winding up or whatever, and then the other party says, but there is an arbitration agreement. And here I strongly agree with the English courts, which says, yes, in principle, as an arbitrator, you can never order declaring someone insolvent. That is something, a power you normally do not have. Yeah? But that should be something which the arbitrator may determine whether there are the requirements met, yes or no. And then the state court may jump in and say, okay, now we declare that particular party insolvent. I think the English made a very good approach in here, saying in the Liverpool football club, Fulham Football Club decision, where they said just the mere allegation that you have winding up here is not sufficient to circumvent the arbitration agreement. And what you mentioned, Vesna, there are 2 points. There are 2 quite interesting German PhD theses actually on arbitration, on conflict of law rules for arbitrators, which come very close to what Lucas has suggested in saying, forget about all the conflict of law rules for the courts. Yeah, for arbitrators, there is just very few basic rules, and you apply that. But and that's why I also like the French court you were referring to as wrong. it shows really the danger there. As an arbitrator, you're facing suddenly an arbitration law from a completely different jurisdiction, and you're not 100% sure whether it's now the insolvency administrator who becomes really a party, is representing the debtor, what you have to do exactly. And then if you come with that very strict approach and said, unless you comply with our understanding of insolvency law, it's contrary to public policy, you put awards at risk at in my view, which is an undue risk. Yeah? So I would hope that courts take a more lenient approach, saying, okay, the arbitrator may have got it wrong, they may have ordered someone to pay something, but including is there is something where we have the claim exists, we have a declaration that the claim exists, and we put that into our registry instead of declaring the award completely inadmissible or non-enforceable.
And okay, so it's a scenario where everyone is expected to play a certain role. As Professor Mistelis said, that the arbitrators have to be pragmatic. The courts, as Dr. Crowley suggested, are bound by the conflicts of laws rules. Then there is the scope for abuse of bankruptcy provisions, which personally in my career as a lawyer I've seen quite a lot, because it's a great arm twisting tool and you can extract the best. But then you still cannot calculate how exactly that's going to work out. And sometimes things go beyond the hands of the creditor, who was seeking some quick money out of this arm twisting tactic, and things go way beyond control for the debtor. And then once the rigors of the bankruptcy laws are triggered, you're just going downhill. And even by the time you recover out of it, or there's a court order in your favor a few months down the line, you still would have lost a lot of capital. You still there might be some irreparable damage for at least the near future. So, and I remember, Dr. Shaughnessy, during the first dialogue that we had, we were talking about, if scope and scenarios for advocating a case for arbitration, to protect arbitration. So now to talk about that, and I know Dr. Kroll, you touched upon it briefly, but to talk about protecting the arbitration, what do the courts do? What can they do? What do you think has been done, is being done, how the English approach is, or how the Swiss approach can actually, carve the way out for the year or two to come, when we're going to see a lot of these insolvencies and arbitration agreements colliding?
I'm not sure who you're asking the question to Stefan, I think.
Yes, to Dr. Kroll, yes.
It's, as I said, there is an issue here which will never be resolved due to the complete territoriality of the laws we have here. That is, every jurisdiction will take its own approach, and the only thing you can do internationally is try to first harmonize the insolvency laws. Yeah, we had that with the ancestral model law on insolvency, which has been adopted in a number of jurisdictions, which will deal with some of the problems. But just taking the one case we discussed, the Canadian case, where you see the local insolvency law is very often so unclear, that you have two discussions or two courts at two different instances coming to exactly opposite results. And that makes it also for anyone operating internationally very difficult to really know what is in the end going on. Coming back to the Riverrock part, I think what the English courts try to do there with the anti-suit injunction, protecting the insolvency or protecting the arbitration, is an approach which might help you in these type of particular cases, where you're not 100% sure whether the insolvency is a way of getting rid of obligations. On the other hand, as I said at the beginning, I have a certain understanding of also making the distinction between these are claims covered by the or these are claims which belong to the insolvency administrator, and these are claims which belong to the original debtor. And we have a little bit the same situation that distinguishes the River case a little bit from the earlier case, the Nuri case, which we had mentioned as well, where you have maybe claims belonging to the insolvency administrator, which are largely in parallel to claims belonging to the debtor, where the debtor said, you have defrauded me and I have a claim against you, and the insolvency administrator says there's an annulment issue. To some extent, you can compare that to the situation we sometimes have with tort claims and contract claims, where you say there's a particular contract claim which is covered by the arbitration agreement, while the tort claim may not be covered by the arbitration, but since they're so closely related, we think that is covered by the arbitration agreement as well. And we discussed that at the beginning. In the end, it's always a question of really the particular facts of the case. And here, I think there is not sufficient, and I think the judge regretted that as well, that he or she didn't have sufficient time to look into all facts of the River case, but had to deal with it in an anti-suit injunction within a very short period of time, impressively short period of time, where you say you're really surprised by the quality and the discussion there and the way they are manage that within such a short period of time in COVID crisis.
Thank you. Dr. Shaughnessy, Dr. Lazic, Dr. Mistelis, any quick take on that before we move to some questions?
Yeah, I think that one of the problems that we see reoccurring here with all these reoccurring issues is the lack of predictability for transnational traders and enter into agreements. They enter into these agreements in order to assess and assign risks, in order to create some predictability. There might be opportunities to try to pick up some types of, even if it was for the trustee, there's a lack of predictability. And as Vesna said, it would be desirable if we had greater uniform regulation in the field. And as Stefan has pointed out, the UNCITRAL model law has existed for a long time. It covers some issues, but not all, and it's not widely adopted. We have the recasted EU regulation that helps to provide some, but still the landscape is scattered, and it's going to continue to be a minefield, which is a gold field for lawyers.
I'm glad to see that Stefan has some sympathy for English law and how courts can really operate. But of course, the question of how the application came to the court, I think in the end of the day, they had to work with the submission of the parties. I think one of the points that has been brought up in the questions, but also in the chat, is that the problem remains that if we take the view that the insolvency courts assumes a role of supremacy or primary role in all insolvency matters, even if the arbitrators think that they have a valid arbitration agreement, this can be suspended. This creates tension. I mean, that seems to be sort of the problem everywhere. And whether this is cast as public policy, whether it's cast as fairness or fair treatment of all creditors, arbitration will always be, in that sense, in a limbo. And I think the question is, what is the extent of willingness of tribunals to be sort of protecting the interests of the disputing parties before them, even if in the bigger picture there are other problems. And so I see that the tension will continue for quite some time.
Dr. Lazic?
Yes, I think I would just like to reiterate the need for a clear conflicts of law rules for the courts, at least. And secondly, I think what is also in particularly confusing for all concerned and the trustees and is this kind of a dual criteria that apply in purely domestic cases and in the so-called cross-border cases. So when one considers and have a look at these foreign insolvencies and then taken by and decisions taken outside of that jurisdiction, we may run into entirely different conclusions about the state of law in that jurisdiction. And I think there we would need really a little bit of more of a balance. First, clearer rules on what effects of insolvency would be recognized in a particular jurisdiction. And second, I always believed that there is basically not clear tension. What sometimes and very often in the literature one would say there is a tension between the insolvency and arbitration. I somehow believe that taking a proper consideration of the underlying policies and purposes of both proceedings, we may find a proper path to proceed. So these are only two questions that I wanted to make. And I see now that in the chat there is a colleague drawing our attention that Spanish law has been changed in the meanwhile and arbitration clauses are no longer invalid. Thank you.
Thanks. So thank you so much. I mean, that was a lot to discuss and digest, and I think a lot of food for thought to think about what's going to happen. Dr. Kroll, speaking of the UNCITRAL model law, there are only 45 countries that have actually adopted the UNCITRAL model law on cross-border insolvency. And I think, I mean, please correct us and guide us, but till the time that gap is bridged, where you have 165 countries signatory to the New York Convention, and then you have just 45 here, and then still insolvency and bankruptcy laws being in nascent stages in their respective countries. India, for example, just came out with the new law 5 years ago, 2016, towards the beginning of the year. There are still talks whether or not cross-border insolvency rules as per the model law will be adopted soon or not. What's going to happen in many other developing countries, and a lot of the transactions actually flow through developing countries. So till that time that happens, there's going to be chaos in terms of, as you suggested, applicability or the extent to which domestic insolvency laws apply. Then, talking about courts, I'm surprised there were only 2 courts in British Columbia that spoke about it. In many countries, you have 3 or 4 or 5 rounds of litigation going up to the Supreme Court, and then, a larger bench sitting there and trying to decide on those issues. And then suddenly a lot of years are lost, a lot of time is lost. And what I was referring to, everyone, was this book by Dr. Lazic. This was written 20 years ago, and I'm pretty sure there's so much that has happened that I think 1 or 2 more books on the same issue can be written by Dr. Lazic. And so, yeah, that's what we're talking about. It's still an underdeveloped area, underdeveloped field, this field of interplay and intersection. But I guess we need to expand this dialogue, trying to cover every single aspect that we can think of, perhaps to also help a lot of stakeholders, gather together to harmonize some of the issues, at least wherever they can be. And I have Prakhar, my colleague, who's been wanting to ask one question that's been going on in our minds for a while. Prakhar, I invite you to please ask the question.
Yeah, I mean, this is been there ever since Dr. Shaughnessy sent us the Petrowest judgment, and I'm kind of baffled. I don't know which way to take, because the 3 major aspects which I think appear, and of course they were covered, but one of the issues which was taken up in the Petrowest case was whether litigation commenced by the receiver against the appellant on the subcontracts is distinguishable by a litigation initiated by the respondents, not represented by the receiver. That's one aspect, and that also leads me to think, how do we take receivers? Because a receiver may be appointed. I mean, coming from India, I know receivers may be appointed in normal civil suits also, and then you might have to go and to what extent is if the arbitration tribunal is seized of such a case, to what extent is the tribunal going to and because of the fact that there might be a challenge to the validity of the agreement, as well as Professor Mistelis was putting across. So to what extent can the tribunal go and see, what law is this, or what law is applicable, or whether this is a real bankruptcy proceeding? And then the another point which I was kind of very concerned with respect to the receiver and the arbitration agreement was when Petrowest says that the receiver is an officer of the court because he's appointed under the bankruptcy legislation rather than a party's representative. So this kind of an understanding in itself is you know it's casting it's creating more confusion, because on one hand we have a lot of developed jurisdictions. We talked about a French approach, the German approach, the English courts, the US courts, but a large part of the world is still struggling with these areas. And when we have divided opinions, I guess to a large extent, it hits the minds of the legislators as well as to which approach to take, how to go about it, because insolvencies are very, very dear to these courts, and they do not let it go about it. Go arbitration. I mean, let arbitration tribunals have a piece in that cake, and then again there comes the question of applicability. Whether the as it was in the Petrowest and other and the French approaches, whether the receiver or the insolvency administrator can pick and choose whether, oh, I want to terminate this contract and I want to enter into an arbitration into this contract. It's all so cluttered. I mean, of course we have discussed it, but this has been running across my head every time that this was being discussed.
If you want a view from me on that, I like strong views on something there. I think the Canadian decision is utterly wrong. If we follow that approach, that in principle the insolvency administrator can select, I take the substantive part of the contract and avoid the other part of the contract as executed contract, then we don't have to continue the dialogue here. That's it. And if you say the insolvency administrator is something completely different, again, if the insolvency administrator is not bound by the arbitration agreement, again, we do not have to continue that. You cannot bring any claim, or here the insolvency administrator can bring the claim wherever he or she wants to bring it. There are considerations in there, because we mentioned that the insolvency administrator may have other positions to take into account than the pure debtor. So okay. There is the international, the public element involved there, which is basically at the heart of the discussion here. To what extent do we give way to this public element? Again, those of you who want to read the first decision, I think that is a quite interesting decision, where they said we have to balance somehow the interest of keeping the estate as large as possible, having one case where we solve all disputes instead of having 5 different arbitrations. And it's just a question, how do I balance that? And that's I was very grateful that the colleague from King's College mentioned the new Spanish law. There is, in my view, at least a development, where you say people recognize more and more that there is a role for arbitration to be played in that area. And when you see the development, for example, in Polish law, they abandoned the strict provision and have now a much more lenient provision, which gives some leeway to the courts that they can take into account the public element in particular cases, but it's not from the beginning arbitration excluded. The Spanish example is another example of that. And to that extent, I think the Canadian decision was a kind of step back, but we see whether it will stand or whether it will be followed somewhere else. I hope not.
Professor Mistelis, a quick take, please.
No, I agree that I think perhaps the signals, notwithstanding the British Columbia, is that there is a higher level of respect for the two systems. And there's, I mean, the Polish example, the Spanish example, the Ukrainian new law, the Greek new law. There's a lot of signals that create a basis for a much more fruitful dialogue, sort of. But what perhaps is not yet clear in direction of travel, and I think Vesna Lazic is right on that, is that I think both arbitrators and judges need a bit of clarity sometimes to know what is in their exclusive domain, and what is within the domain of the parties, and therefore what is in the domain of the parties can go to arbitration. I think that has this very traditional concept of arbitrability, what is the free disposition of the parties, is critical in this occasion as well. And it might be very good circumstances that receivers in insolvency, they will find that an arbitration tribunal will get what they need to get much quicker than going through a national court. So I think there are a lot of good signals, but there's also quite a bit of bumps along the road, and I would see Petrowest as one of these bumps along the road.
Okay,
if I may quickly make just add to what Professor Mestelli said. Does it also depend then on how the courts read Article 2, Clause 3 of the New York Convention? When we have contesting party, one party wants to initiate the arbitration, and on the other hand, you have the receiver resisting it. So the court's approach.
Absolutely. Because if you look at what we cite in our book, the Kammergericht Berlin case, and also some of the discussion in Vivendi, whether the insolvency renders the arbitration agreement incapable of being performed, is valid, but whether it can be performed in the terms that has been concluded or similar terms is a debate that has been brought, and that's actually the way the Swiss courts have decided the case in the end. But the English, that's entirely on point.
Dr. Shaughnessy?
I think that one of the comments in the Q&A that was raised some time ago, that was the question about enforcement. And without getting specifically into the question, I can say that both courts and arbitrators are concerned with the enforcement of the final outcome. And so if we look at the River Rock cases, and then the English court engaged with that a bit, that if the Russian court went forward, the St. Petersburg court went forward, would that result be enforced against the UK-based party? Not when there's been an anti-suit injunction granted. I would say it's unlikely. And if arbitrators grant an anti-suit injunction, will a domestic bankruptcy court care? Probably not. They would say probably their public function is greater. And when you take the arbitration award to a to be enforced in a foreign jurisdiction, will you end up having the conflict there with public interest, whether it be arbitrability, public policy, validity of the arbitration agreement, I love British Columbia or whatever. So whichever forum you're in, you're going to end up at the end of the day probably with an enforcement issue, because it's not likely that it could happen. Maybe you could have a good German arbitrator like Stefan Kroller, or a good Lucas or Dr. Lasvik, who would help the parties reach a settlement. But failing that at the end of the day, you're going to end up with the enforcement issue.
Dr. Lasic, would you love to be that arbitrator?
Just the last point again. I think what I said to have a balance of interest in arbitration, I think the same would go also for the courts, and in particular in the enforcement stage. And again, we would need to give a certain effects to foreign bankruptcy, but then again, what Stefan mentioned, to recognize and see whether this is really true bankruptcy proceedings. Whether do we have the same or similar values in those bankruptcy proceedings? Is the court that opened bankruptcy, was it competent court? And finally, whether again we share the same values, and that's exactly what the United States court decided when deciding on not enforcing the award, stating these are these are insolvency proceedings that have similar aims and similar tools that we use in order to protect creditors and interests of all others in the insolvency proceedings. So, and that is that I would exactly regret the Canadian decision, because I would like to see much more consistency in dealing with the concepts of insolvency law that are really present in basically every insolvency. So executory contracts, avoidance powers, suspension of actions. There should not be such differences in approaches. That would help also the arbitrators in recognizing when and when not to give the effects of the insolvency proceedings. So that's, I think, I would here conclude by this.
Fantastic.
Thank you so much,
I
Professor.
think about all that we spoke, there's going to be a lot of issues that we have to discuss. And so what we're planning is to, continue this dialogue, 3.0, 4.0, 5.0, discussing the various aspects that, that require specific discussions in detail. For example, enforcement is a chapter in itself altogether. And of course, we have to discuss about the roles of parties, perhaps a little more about administrators. But yes, there's so much to be discussed, and I'm pretty sure with these discussions, with the dialogues, and of course, I'm trying to push that each of our dialogue gets published, that we can actually help push for all the reforms that somewhere or the other we all yearn for. Perhaps it might take a little longer, but at least in whatever possible way, that should happen. And with that, I invite Chris back to please share his closing remarks.
I've pushed my chair back from the table. I've had an amazing mental meal, digesting it now. Thank you very much, Ishan, Prakar, Stefan, Vesna, Patricia, Lucas. Amazing again. And I will be looking forward to the next editions of this series. Ishan, you've been recording this, so I think you'll be sending out emails to those who registered but couldn't make it, so they'll be able to benefit from the great discussion that we've been listening to as well. With that, I think I can wish everyone a wonderful night, afternoon, morning, depending on where they're at in the world. And I hope that we'll find some solutions to these dilemmas in the coming years. Sean, anything else?
Yes, I at the end of every event, I like to take a happy screenshot. So if I can request